Hi, welcome. In continuation of our topic on inheritance, today's topic is probate. How probate has to be obtained. My name is Girish Rao. I am advocate and solicitor. I have more than 28 years of experience, and this video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct different courses in law like master in drafting of agreement, master in drafting of pleading, master in RERA, and various other courses. If you want to know more about it, you can connect with Legal Scholar Academy on the number which is scrolling down here. In addition to that, Legal Scholar Academy also conduct a free webinar on every Friday at 7:30 p.m. To know more about it, you can connect with the Legal Scholar Academy, which is number on which is scrolling down here. So with this, let's start today's topic, that is probate. But before I start this topic, it's request to every one of you to subscribe to this channel. If you subscribe to this channel, you will get a notification as and when new videos are brought by you, loaded by us. And all those videos have a lot of knowledge which will be value addition to you. So I'm once again requesting you to subscribe to this channel. And in addition to that, which I'm sure you're going to like this video, also hit a like button. Okay. Now let's start today's topic, that is probate. So in this topic on probate, we are going to cover first is what is probate, when probate is granted or whom probate is granted. Third, next, whom probate is not granted. Third, where application should be made for grant of probate. Then the process to be followed for grant of probate. So first is, what is probate? Probate is nothing but a certified copy of a will issued by the court. So basically, a probate is nothing but a certified copy of a will. That is, a certificate is granted by the court. Yes, this is a will which was executed as per the requirement under the law. It has got, court is not concerned with what is there in the will. Court is concerned only one thing, whether the will is executed as per the requirement of the law. So when we are talking of the probate, you have to understand what is there for the, that the will should be, or rather how the will should be made. For that purpose, we have already made another video. You can check that video. Then you can recollect that in that the requirement of the will is that it should be, the person who has made a will, he should be capable of making a will. Next is, it should be signed by the person who has made the will. Then third is that there should be distribution of the property. This is not something legally which is required, because what else otherwise video or the will be made. It's for distribution of the property. So there should be a distribution of property, otherwise the will is meaningless. Then there should be an appointment of executor. Reason behind is that the person has directed the property has to be distributed as per the direction which is given in that will. But then who is going to distribute that property? For that purpose, a person has to appoint someone as an executor. If executor is not appointed, then the person who is entitled for the benefit will have to make an application for appointment of as an administrator. That is, you will have to make an application for letters of administration. Then for a will, there has to be two witnesses. So these are requirement of a will. So court is going to check whether this requirement has been fulfilled, and if it's fulfilled, the court is going to grant a probate if there is an executor to the will. Then whom probate is granted? As I told, probate is granted only to an executor appointed by the will. The appointment of the executor could be by express or from the necessary implication also. So there could be an indication in the will that person, XYZ person, is the executor of the will. So if that is there, also that will be sufficient. But it will be always better to clearly mention in the will that will XYZ person is appointed as a will. You can check in the video of the will which is also made by us. Then next is who is an executor. As I told earlier itself, executor is a person who has to execute the will of the deceased person as per the testamentary document, that is the will. Than whom probate cannot be granted. For certain person, probate cannot be granted, which is basically a person who is a minor or unsound mind or an association of individual, unless it's a company which satisfy the condition which is notified by the government. Basically, there are certain companies who deals, only their job is to administration of the probate or those things. If that is what the object of the company, and the deceased appointed that company as an executor, then they can also act as an executor of the will. Then where should application be made? Application, that the petition should be made in a district court, except in Bombay. Bombay, it's all a different process altogether. For that purpose, we will be making a separate video on that topic on for a probate in Bombay, because its application has to be made in the Bombay High Court and the process is totally different. Then, and further, in Bombay, it's mandatory that probate should be obtained if will is made in Bombay or will is made in respect of any property in Bombay. So it's mandatory in Bombay that probate should be obtained, and it is not mandatory for to obtain probate in rest of the state if property is not within the Bombay. So in Bombay, property is in Bombay or will is made in Bombay, then it's mandatory to obtain a probate. And process for Bombay is different, which we are making a different video for that. Yes. Then coming back to the topic, what is that the application should be made to the district court. In that, you will have to tell what was the time the testator died. He has left a will which is annexed. Then he is the person who is the executor of the will, the amount of asset which are likely to come to the petitioner's hand, or petitioner is executor name in the will. So all those things will have to be described in the petition, and after that the process which will be followed by the court before issuing the probate. First process which is there, a publication citation, or its word is used, citation is basically publication of a notice in the newspaper inviting if anyone has objection for issuing of the probate. So those person who are there who desire to oppose it will have to come forward and oppose that application, or if there is already a caveat which is filed in that case also, then it becomes a contentious matter. If there is a if there is a caveat or someone is opposing the will, then it becomes a contentious matter, and then it is treated as a suit under section 295 of the act. Then if it is not opposed, then court will grant a probate under its seal under section 289 of the Indian Succession Act. Now again the question may come, if probate which is granted, whether it's final? No. It can be revoked under certain circumstances, like if it is obtained by fraud, if it is obtained by not disclosing the true fact, or there was material change. So probate is not something which is final, but it can be revoked also. So you keep that in mind when we are talking about, or when we are discussing about the probate. It is not final, it can be revoked when an application is made and the circumstances for revocation is shown in the application, then probate can be revoked also. So this was my brief talk on the probate. So thank you for watching this video. And if you have any query, ask it in comment box. We will respond to it. And don't forget to give a feedback on this video. So once again, reminding you to subscribe this channel if not already subscribed, and don't forget to click a like button to this video, because I'm sure you might have liked this. Bye bye. Take care. Happy learning. Bye.